I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Hey everyone, welcome back to the Prosecutor's Legal Briefs. I'm Alice, and I'm joined, as always, by my preeminent co-host, Brett.
Thank you, Alice. It's so great to hear from you. I just can't tell you how happy it makes me to hear from you. I've been in a training for the last week, so I've been out of town. I haven't got to hang out with you, and I'm just over the moon that we're doing this tonight.
Let's just say work is not the same without you. It's a sad place without you. I've missed you.
Aw, I've missed you too.
Well, partly I miss you
missed you
because I can hear, we share the wall at our office, and I can hear all your conversations through the wall, and it's really sad not to have someone to eavesdrop on.
Just silent. I guess I need to stop saying all those bad things about you then.
Well, you make up with them with our other podcast and your wonderful words for me. So
We'll just
call it even.
There you go. We got to keep you grounded, Alice. It's like the Roman emperors who had someone who whispered in their ear, "You are only a man." In this case, you are only a woman. You are only a woman.
I am but woman.
You are but woman.
Well, Brett, welcome back. And I want everyone to know that Brett, got off an airplane, just rolled into town, hasn't seen his family all week, and he texted me and was like, let's record tonight. And boy, do we have a show for you tonight, because this is something we could probably talk many episodes about, and we just indeed might. But it's something that comes up often, and it's a phrase that you all have heard before, but do you actually know what it means? And that is ineffective assistance of counsel.
As a matter of fact, you heard it in our second episode, our second Legal Briefs episode, and we were talking about sort of a flavor of it, the Supreme Court opinion that recently arguably limited your ability to raise it in certain circumstances. And people reached out and wanted to know more about ineffective assistance of counsel itself. It's something we've talked about in the other podcast in some different contexts, but maybe not in as much depth as we're going to talk about it today. And Alice is 100% right. This is a topic that comes up in really every appeal, certainly every innocence case. If you know a case where there's a claim of innocence, there's always going to be a claim of ineffective assistance of counsel, even if it's not put that way. You'll hear people talk about the lawyer wasn't any good, he didn't do any investigation, he barely talked to his client, he showed up drunk, he wore the same rumpled suit every day. I mean, I'm just thinking of things I've heard in different cases. Those of you who liked Making a Murderer, Brendan Dassey's lawyer really comes off as an example. I mean, in that documentary, they really wanted to present him as sort of the quintessential ineffective attorney. Stephen Avery's lawyers were very good, and they're sort of the heroes of the documentary, but Brendan Dassey's lawyer just really comes off bad. And that's really something that people point to, because a lot of times, by the time you're hearing a innocence case, a claim of innocence, a habeas case, many years have passed since the initial conviction, and really what you're left with is ineffective assistance, because your direct appeal, which is your appeal after your conviction, where you're really arguing about whether you're guilty or whether the judge ruled incorrectly on certain legal questions, or whether the jury was biased and that sort of thing, whether the prosecution withheld evidence, that appeal has been decided long ago, and you lost it, and that's why you're still in jail. So you really do turn to this ineffective assistance thing, and it's really important, and that's why we wanted to talk about it.
Absolutely. And like so many legal terms or legal principles, there is a famous Supreme Court case that tell us what ineffective assistance of counsel is, and that is Gideon versus Wainwright.
It's not actually that one.
Is it not? Oh, God. That's the one where that's when he gets counsel, right?
Yeah, exactly. That's the first one.
Before you can get, you don't have to cut that out because it's just true. Yeah, what I was thinking Gideon's Trumpet. Is that the movie?
Gideon's Trumpet is about Gideon versus Wainwright. Yes.
Oh my gosh. You know what? When we start recording at like 9:30, this is what happens. Well,
This
Brett,
is what
before
happens.
we get to ineffective assistance of counsel, you have to, of course, establish the right to counsel at all. Because if you don't have right to counsel, then you don't have right to effective counsel.
And we talked about that in episode 2, because you do not have a right to counsel at a habeas proceeding. And because of that, you don't have a right to effective counsel, which means you can't make this ineffective assistance of counsel claim. But you do have a right to counsel at trial, but it wasn't always that way, or at least not in the way we think of it now. Not until a case called Gideon versus Wainwright. It's a very famous case. There's a book written about it. There was a movie made about it. And it's kind of funny. Some of the biggest Supreme Court cases have humble beginnings. And in this case, you had Gideon, who was kind of a local criminal, sort of down on his luck guy, low-level criminal. He breaks into a pool room in Florida to rob it. Now, he doesn't succeed, and he's charged with a misdemeanor. So, misdemeanor crime, barely anything. He goes to trial on this misdemeanor charge, and he demands a lawyer. And the judge says, I'm sorry, you can have a lawyer, but you got to pay for it yourself. And he doesn't have any money, so he can't pay for a lawyer. And he says, no, the Constitution guarantees me a lawyer, so the state should provide me one. And he's kind of, okay, whatever, Gideon, you know. and he goes on to represent himself, and he actually does a pretty good job. And in the Supreme Court case, I actually sort of praise him for his skill as a pro se lawyer. But in the end, not surprisingly, and probably more to do with the fact that he was very clearly guilty than that he didn't have a lawyer, he does lose. And he swears he's going to take his case all the way to the Supreme Court, which is something you've heard many an unlucky litigant say. But usually, those are just words, because the Supreme Court doesn't take many cases. We've talked about this a little bit in the past. The Supreme Court takes, what, Alice, 30, 40 cases a year of the thousands and thousands of cases that are brought before them?
Isn't it more like 75? Am I wrong about that?
Maybe it's 75. I'll say 75. I don't know. I thought it was less than that.
Wait, 1 second. It changes over the years. This is just going to be an episode of us spouting off legal knowledge that's incorrect.
I'm going to cut this part. No, you're right. It's 70 to 80.
Right?
There you go.
Okay.
There you
There
go.
was
Look
a
at
time
you.
where it
Look
was like
at
30.
you.
Look, it's
Yeah.
between 70 and 80 cases a year.
You did such a good job. I'll leave that in there.
I legitimately mixed up Gideon. So
It's fine. It's fine.
Okay,
The people love it. The people love our foibles. So as Alice noted, it's more like 70, but we're talking about 8,000 or so petitions a year, and they are granting oral argument on 75 cases. And that's of the petitions that are filed. There are thousands of more cases that no petitions filed, there really isn't an appeal, or it ends after an appeal to the circuit court. So it's just very, very few cases that make it to the Supreme Court. But when Gideon appealed, they actually took his case. Now, what's interesting about this is Gideon, he had some room to stand on. This was a developing area of the law, but nevertheless, he had a case up against him that didn't help. It's called Betts, and the Supreme Court had ruled in that case that yes, the right to counsel is fundamental, but not fundamental such that the state not only has to acknowledge it, but has to pay for it, has to provide you a counsel. As we all know from your Miranda rights, you have a right to an attorney, and if you can't afford one, one will be provided to you. But not at this time. At this time, the Supreme Court had said, no, you have a right to counsel, but you don't have a right to have one paid for. And today that seems strange because we live in this, you just know that if you get arrested,
world.
You're going to be provided a counsel. Yeah, we live in a Gideon world, but you have to remember the right to an attorney is based on a time, if you go back to the 1700s when the Constitution was ratified, you had a situation where the British did not always allow you to have representation. It was one of the things that people feared from their government is that they would deny you the right to go out and hire a lawyer of your own to represent you and your interest. So it was very important to the founders to protect that right, to be able to go get yourself a counsel. But nobody really thought of it as, well, not only can you go get one, but we're going to pay for it. And it wasn't until this case comes along, I believe in 1962, that the Supreme Court said, you know what? We're going to reconsider this precedent that we've had for a long time, and really that goes back until the founding of the country. If you think about it, we're going to reconsider that and look to see whether or not maybe the right to counsel goes beyond merely we can't deny it to you, but we have to give it to you.
And this is truly groundbreaking when it comes out. And here is what the Supreme Court said when it reconsidered its previous decision. From the very beginning, our state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. The right to be heard would be, in many cases, of little avail if it did not comprehend the right to be heard by counsel. Even the intelligent and educated layman has small and sometimes no skill in the science of law. If charged with crime, he is incapable, generally, of determining for himself whether the indictment is good or bad. He's unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial without a proper charge, and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he have a perfect one. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though he be not guilty, he faces the danger of conviction because he does not know how to establish his innocence. This is huge. All of you listening to this may be thinking, well, of course. But like we've already gone through the procedural history of how the Supreme Court ended up here, this was not the case. They're saying essentially that if in fact justice is to be blind and the law applies equally to all, not just the application as to who is prosecuted, right? We've talked about this, how the ideals of justice is that the law applies equally to everyone, no matter what they look like, who their parents are, how much money they have. But here, the Supreme Court is expounding upon that principle and saying not only is it equally applied to you, the law is equally applied to you, but your defense to it is not only that you can be heard. You don't just have a right to be heard, you have a right to be heard through counsel who has specialized knowledge in the court system and in the legal system. And you can see how this can be very, very useful. I mean, the reason we take so many sidebars and we have this entire new podcast called Legal Briefs is because there's an entire area of law that the layperson doesn't know. You don't know what the letters 404B mean. Those are the rules of evidence. That's why we explain those things as we talk about in this podcast and also in our other podcast, The Prosecutors, throughout, storytelling of true crime stories. These things are not just known to everyone. They are knowable, but they are not naturally known to people if you haven't studied it.
And this is really the development of negative versus positive rights in the Supreme Court. And you see this a lot in the 60s. Miranda's another good example of this. So a negative right, it's not a moral judgment on it. It just means you have it without any action. So you have a right to counsel. Nobody has to do anything to give you that right. As long as they don't take steps to prevent you from having one, your negative right is protected. You can go out and hire anybody you want. That's your right. A positive right says the fact that you have the right means there is an obligation on the state to provide it to you. So you have a positive right to counsel. It's not just that you have a right to it. We have to give it to you if you can't afford it. Miranda's a similar thing. You have a right to remain silent. Well, now under Miranda, we have to tell you that you have a right to remain silent. The state now has to take an action to make sure that this right that you have is realized in sort of a concrete way. And look, somebody was asking about this and asked us to talk about this some more, was concerned that one of the problems with habeas is, does it mean that someone who has less money than someone who has more money has less possibility to succeed on habeas? And yes, that is true. If you can't afford a lawyer, a habeas attorney, it's much more difficult to succeed on habeas. And a lot of times, for death penalty cases, for instance, you almost always have a lawyer because there are so many organizations that are dedicated to ensuring that everyone on death row at every stage of their litigation has an attorney. But if you're put in jail for, petty theft or robbing a bank, you're probably not going to have a lawyer unless you can afford one. And less of a problem at the habeas stage than it is at the trial itself. But, I think it's a legitimate thing to say it's still a problem. But nevertheless, that's a little far afield of where we are today. This is the Supreme Court saying for the first time, definitively, they'd hinted at it before, but definitively, you have a right to a lawyer, and if you can't afford one, the state's going to have to provide it. And so Gideon goes back and has his attorney, and I don't actually know what happened to Gideon. I never read Gideon's Trumpet or saw the movie, so I'm not sure if he won when he went back down and had his second trial with his attorney or not. We'll have to look that up later. So great. From that point forward, 1963 on, you're going to get a lawyer. No matter what, you're going to have a lawyer for your trial. If you can't afford one, state's going to pay for one. But that raises a new question. What if your lawyer is terrible? What if he sleeps through the whole trial? Or he's drunk the whole time? Or he gets up at closing and says, you know what, after hearing all that evidence from the prosecution, this guy is clearly guilty, and you probably should just find him guilty. I'd find him guilty if I was a juror, right? If your lawyer says something like that, what happens? Do you have any recourse? And the answer for 20 years or so was that's just tough. You have a right to a lawyer. You got a lawyer. He was terrible, but he was there. And it wasn't that you could never get relief if your lawyer was terrible, but they really had to be bad. I mean, bad to the point, really my last example might be a good example, where they essentially, not only are they not doing a good job, but they are shocking the conscience of anyone who looked at it, how bad they are. That was sort of the standard. It was like a last resort, extreme circumstance. There is an out where maybe you can have a new trial if your counsel is that bad. But that was it. Beyond that, you were just stuck with them. So then in 1984, so about 21 years after Gideon versus Wainwright is decided, the famous case that Alice was referencing earlier, Strickland versus Washington, is decided. And that really changes everything about habeas, appeals, and how we look at these cases.
Absolutely. So notice, by the way, how slowly the law moves, and there are benefits. There's obviously pros and cons to this, but note how this is decades later that this kind of jurisprudence is developing. And now, like most people who lend their name to famous cases, Washington was really one terrible person. Over the course of 10 days, he terrorized the state of Florida with a crime spree, including 3 brutal stabbing murders, torture, kidnapping, severe assaults, attempted murders, attempted extortion, and theft. When Washington was appointed counsel, the attorney took a deep dive into his client's file and fell into what can only be described as an equally deep depression. Not only had Washington confessed to 2 of the murders, the evidence against him was overwhelming. Concluding that Washington's case was helpless, the counsel did very little to defend Washington, hoping instead that by not putting on much of a defense, the judge would take pity on Washington and at least spare his life. He did not.
So Washington's sentenced to death, and he appeals his death sentence. And like so many people that will follow him, he doesn't argue that he's innocent. And this is something that I've said before, and I just like to reiterate it. Yes, there are people on death row in innocence cases who are saying, I am absolutely innocent of this. I didn't do it. I'm an innocent man. The vast majority of these cases, they're not saying that. They're saying their lawyer was ineffective. They're saying, yes, they they did it, but if the lawyer had only done all these other things, the jury would have taken pity on them and not given the death penalty. And Washington is pretty much making both those arguments. Now, he's not making an innocence argument, but he is saying, look, my counsel didn't do anything. He didn't do anything to defend me, on the one hand. And on the other hand, his argument for why I shouldn't get the death penalty was basically, well, you know, he's accepted responsibility. Look at our terrible defense. We obviously didn't fight it. You should take pity on him. There was no sort of investigation into Washington or why Washington was the way he was or why he committed these crimes or maybe were there drugs involved? Was there mental illness involved? Was there a prior history of abuse? He didn't do any of that stuff. No mitigating investigation to try and show this judge that, yeah, this is a terrible person. He needs to go away forever, but take pity on him. Don't give him the death penalty. So he goes through this process we've talked about before. He's going through the state courts, he's going through the federal courts, and the lower courts it was all over the place. They had sort of a smorgasbord of standards. So there were states that had ineffective assistance of counsel standards. Florida was one of them. It was sort of amorphous, not very friendly to defendants like most of these standards. And they basically said, look, if your counsel is present and he's alive and he's conscious and he's not drunk, that's good enough. That's sufficient. We're not going to second guess him. We're not going to second guess him. So, sorry, he was there. You had a counsel. That's it. Well, the Supreme Court disagreed with that. The Supreme Court said, no, that is not what we're going to do. We are going to finally establish a standard for lawyers who represent clients in a defense case about what they have to do and when they are ineffective, so ineffective that they are denying counsel to the defendant. And that's really the key here. Remember, we start with Gideon versus Wainwright for a reason. If you were entitled to a lawyer, in Gideon, they said, if that means anything, if it's going to mean something, then it has to mean that a poor person who can't afford a lawyer gets one. It has to mean that. Because otherwise, the right doesn't really mean anything. Same thing here. If you have a right to a lawyer, it can't mean that some guy who just happens to have a piece of paper on his wall that says he's a lawyer who does nothing and isn't in reality, isn't in any way that matters a lawyer, that can't be enough. That can't satisfy that because you're not really getting the counsel to which you're entitled. So basically they said when your lawyer is so defective that he essentially is not acting as counsel anymore, then your right to counsel has been violated and you're going to get another trial. And in order to put that into effect, they had to create a standard that could be applied. So here's what they said. They said that a person who happens to be a lawyer is present at trial alongside the accused, however, is not enough to satisfy the constitutional command. The right to counsel is the right to the effective assistance of counsel. And here's the standard they created to judge that. First, the defendant must show, and the burden is on the defendant. So if you're claiming your counsel is ineffective, the burden is on you. First, the defendant must show that counsel's performance was deficient. This requires showing that counsel made errors so serious that counsel was not functioning as the counsel guaranteed the defendant by the Sixth Amendment. Second, the defendant must show that the deficient performance prejudiced the defendant. This requires showing that counsel's errors were so serious as to deprive the defendant of a fair trial, a trial whose result is reliable. Unless a defendant makes both showings, it cannot be said that the conviction or death sentence resulted from a breakdown in the adversary process that renders the result unreliable.
And the standard was very high. They went on to say judicial scrutiny of counsel's performance must be highly deferential. It is all too tempting for a defendant to second-guess counsel's assistance after conviction or adverse sentence. And it is all too easy for a court examining counsel's defense after it has proved unsuccessful to conclude that a particular act or omission of counsel was unreasonable. A fair assessment of attorney performance requires that every effort be made to eliminate the distorting effects of hindsight, to reconstruct the circumstances of counsel's challenged conduct and to evaluate the conduct from counsel's perspective at the time. Because of the difficulties inherent in making the evaluation, a court must indulge a strong presumption that counsel's conduct falls within the wide range of reasonable professional assistance. That is, the defendant must overcome the presumption that under the circumstances, the challenged action might be considered sound trial strategy. And this makes a lot of sense that the standard has to be so high because we want finality, and it is not uncommon to go through trial and to have a conviction. And we don't want it to be a loophole that people can always have second, third, fourth, fifth bites of the apple just because they've been convicted or sentenced to a particularly high sentence, or say to the death penalty. And the court is not saying that it wants to replace the judgment of counsel, because that's the thing about being counsel, about being a lawyer. We are judged on our thinking, right? What we are being judged on happens inside our brain. We do not have something like, say, a surgeon has a surgery in which you can see if certain protocols were met, that you can compare stitches, the right type of stitch that should have been used in the circumstances. Being a lawyer is to use your judgment continuously and to weigh the pros and cons of steps. It is a constant choose your own adventure. Every single turn has another decision to be made. And of course, there are some blatantly wrong decisions you can make, but really to be a lawyer is to be a person making judgment calls at all times of the day.
And I would just say, a lot of you guys, I mean, if you're listening to the show, you probably consume a lot of true crime. And this is something you can apply whenever you're listening to true crime, watching a documentary. If the criticism that you're hearing of the lawyer is something that could be called a trial decision, a strategy decision, a tactic, then it's not going to be ineffective assistance of counsel. Those of you who are lawyers, if you've been at trial, any kind of trial, I don't care what it is, from a one-day trial on a misdemeanor or a small claims issue to a huge litigation involving millions of dollars or a death penalty criminal case. You make decisions all the time. You have to make choices all the time about the evidence you're going to put on, the questions you're going to ask, the defenses you're going to use, the prosecutions you're going to have. Alice and I, our trial we had earlier this year, we were making decisions about witnesses we were going to call on the fly every day. Every day we would meet at the end of trial. We'd talk about the day, how it had gone, how we thought things were going, what we thought the jury was thinking, how the timing was. And we would make decisions where if things had gone differently and we had lost, people would have second-guessed us and been like, I don't know why you did that. We had a cooperating co-defendant we didn't call, who we had prepped and was ready to go, and we didn't call him because we made the strategic decision that it wouldn't help our case, and it probably, because of the length of the trial and everything else, it would be a net negative. We made that call. If we had lost the case, people would have asked, why didn't you call that person?
And not even just who we were going to call. Literally every question, we were on our feet 10, 11 hours a day in the courtroom, and, there were witnesses on the stand for multiple days. Each question you had to adjust. And so, for example, if we had prepped a witness to say, was the traffic light red? And you thought that the witness was going to say red, and it's your own witness, and you've written reports saying that this witness has said the traffic light was red. And then you ask him the question, what color was the traffic light? And he says green. You have to decide at that very moment, am I going to impeach my own witness? Am I going to have him clarify? Am I going to just completely switch gears and pretend like I never asked that question? Or do I embarrass him on the stand, or worse, call him a liar? These are all, we're just giving you a flavor of the types of trial decisions that happen at every turn and every corner. Each trial, let's say a one-day trial, a super short trial, a one-day trial, you are called to make, I don't know, hundreds, maybe thousands of trial decisions, and then extrapolate that out to a week-long trial or a month-long trial. And you can begin to see how many minute decisions could be questioned and what the what the court is trying to say with this high standard is we will not sit on a lawyer's shoulder and critique every move they make if it could be up to discretion, because we are not in the business. There's no one size fits all for law, and we cannot be there to sit on everyone's shoulder to a judge whether that one move was ineffective.
And so you've already got this very high standard. To even show deficient performance is really difficult. It can't be a strategic decision. It can't be with the benefit of hindsight. It has to be something that if you were sitting there in the courtroom and the lawyer did it or didn't do it, you would immediately be like, what in the world? That is crazy. No competent lawyer would do what they just did. It has to be something like that. But that's only step one. So step two is, in addition, you have to show that the fact that this counsel was not functioning as a lawyer prejudiced him in a concrete, demonstrable way. It hurt him. It hurt him and his case in a way that you can point to and that you can show affected the outcome of the case. And this is what the court said about that. The defendant must show that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. So if you look at the error and you say, oh, man, that was a dumb thing. No lawyer would have done that. Totally ineffective. Shouldn't have done that. But if you look at all the rest of the evidence, you look at how the trial went, you compare that to the mistake, probably not going to matter, right? Then, even though you showed the deficient performance, you didn't show the prejudice, and therefore, you wouldn't win on that. And this goes back to something we've talked about a lot in the other show. You're entitled to a fair trial, but not a perfect trial. And it is not good enough to point to some error, no matter how egregious, with some exceptions. I mean, there are things they call structural errors. And structural errors mean that if it's a structural error, you get a new trial. So a good example of that would be if you racially discriminate against African-American jurors, for instance. That's a Batson issue, and if that is found to be the case, that's it, new trial. Doesn't matter if, everybody agrees that no jury ever would have found you not guilty. Doesn't matter, you get a new trial, it's structural. But those are very limited. Something like this is not structural. So you have to show prejudice. You have to show that it matters. We've talked about this so many times in so many cases where people bring up, well, he should have done this, and this lawyer should have called this person. You guys remember Murder and Alliance? We talked about there was this argument that there was this witness who said he saw someone coming out of the house that day carrying garbage bags, and the lawyer should have called that person, and the fact that he didn't is ineffective assistance. And you looked at the actual transcript, and it turned out that the guy wasn't really clear about whether or not the person was coming out of the house. He wasn't really clear when he saw him, or whether there was somebody that it wasn't somebody that looked like any of the possible suspects. I mean, his story was just really weak. It was really weak. So even if you could say the lawyer should have called him anyway, which you probably would not get to that because the weaknesses in his testimony are reasons for the lawyer not to call him, strategic decision, but assume you got past that. The fact that his actual testimony would have been pretty weak, especially up against all the evidence, means you're not going to win on ineffective assistance of counsel. So here you have this case with Washington. Washington wins. He establishes this new standard for ineffective assistance of counsel. Good for him, right? Well, no. He may have established a right to effective counsel, and he may have set the standard by which courts were going to judge whether a counsel was effective, but he himself failed the standard. And the court said, under this standard, your lawyer, who was basically so depressed by the overwhelming evidence that he didn't do anything, he wasn't deficient. And 2 months after winning essentially this Supreme Court case and lending his name to a rule that has been applied in thousands of cases, 2 months later, he was executed by the state of Florida. So his counsel might not have been much of a counsel, but the evidence against him was just too much to overcome.
I think when we first started, we said these episodes were going to be 20, 25 minutes. And obviously we love to talk. So we've already hit more than half an hour. And we hope this law lesson has been helpful for you. If you take away nothing today, note how common law works. Note how these opinions all talk to each other and they build upon each other. We didn't end up at Strickland from no right to counsel. There was an obvious discussion over time among the justices, among the Supreme Court, to build up to where we are today. And that is how our common law system works. And it's a fascinating one. And that's why we tell you to go read these opinions for yourself, because it is not just the holding that matters. It's not just a clickbait article that matters. It's the reasoning that matters and how the courts reach their ultimate decision. So even though the Supreme Court said you need someone with specialized knowledge, even though the courts have said that you should have access to counsel when you've been accused of a crime, the reality is all court opinions are accessible to everyone. They are written in our language. They should not have that much legalese in them. It shouldn't take any specialized training in order to understand the reasoning. So if you want to learn more about this, you should go read these opinions, and we'll make them available to you as well. So is there anything else you'd like to add, Brett?
We were asked to cover this by Whoa Son, and he asked us, is there a famous case that we can use to sort of exemplify this and explain how it might work in real life? And, we looked, and I don't know about any famous cases, but we did find one that I think if we go through it, we might see how this standard is applied. And that is the case of the state of Maryland versus Adnan Syed.
Just end at Adnan?
Well, you gotta say the thing.
Until next time, then, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.